This is Newsline. Thank you very much for choosing us tonight. And I don't want to waste any time. I want to welcome the legal minds in studio and, of course, those who will speak to the matter on the table. And as far as the national institution is concerned, the concern right now is the position of the Deputy President, who is now in court. Remember, we followed closely from the time the motion was presented in Parliament, that is the National Assembly, to the public participation and to the Senate. And now we are in the courts. This was day one, as per the dates with the court. And I want to appreciate, of course, in studio, Charles Munyui, who is a governance consultant. Also in studio is Areba Samba, who is a lawyer, and Ishmael Nyaribo, who is also a lawyer. Now, even as they give us their opening remarks, let me start with, of course, Charles Munyui, seated at my far left. Welcome to the studios.
Thank you very much. It's always a pleasure being here. Are you looking good?
Thank you very much. So are you. And I know that was a light moment for Areba there. Areba Samba, who's a lawyer. You equally look good. Welcome to the studios.
Thank you so much.
Yes.
Thank you for having me.
We're looking forward to your sentiments. Ishmael Nyaribo, welcome to the show. You're also a lawyer, and thank you for creating time.
Thank you.
I'm looking at the order here, and it's interesting how things stand out on the day one in court with, counsels there or advocates having a bit of a conversation on who should speak first and who should sit down and who was younger before the other was born. Let me start with Ishmael on this one.
I think
a light moment or a serious moment, that
well,
was?
for me, it's a light moment, and it's also a learning moment for especially the upcoming lawyers, because, I mean, you really need to understand the ethics and the etiquettes within an industry, who goes first, who was sworn in earlier than the other one, and in terms of who is a senior advocate is slightly different from who is a senior counsel. And we know it within the fraternity that those who under the Senior Counsel Act have been nominated and declared senior counsel, then they rank higher in if you may say that who is higher, who is following. But it is an important, I think, event in the country. It shows how democratic we are. It shows how legal minds can argue. It sets a good tempo. In fact, it takes away the pain of the Deputy President that has been going on for long when you look at the kind of the jokes, the light moments in the courts. Yeah.
It's interesting that we also had one of the lawyers refer to that moment that he should have been allowed to speak, referring to the particular session as a healing process. I don't know what you picked, Areba, at that point in time. It's quite interesting how much sensation is equally happening in the corridors of justice.
I think one of the things you need to realize is that this is a very momentous occasion when it comes to the legal sector. And I think the only one that we ever experienced since this constitution came into place is the presidential petition, the petitions which have been there. And then the next one has been, I think, the BBI case. It was a monumental time. And now it's a precedent-setting moment in that we're trying to walk through the impeachment process of a sitting deputy president. If you go around very many countries, you realize that this is a process that they have never undertaken. But hey, we have gone into the books of record in that the person of Honorable Rigathi Gachagua was the deputy president a couple of days ago. Parliament has made a decision. The Senate has made a decision on his impeachment. And now the last straw is in the judiciary, so that then at the end of the day, the judiciary can give guidance in terms of what happens and probably how it's supposed to happen. As I've said elsewhere, is that one of the things that will come out of these conversations at the end of the day is how to impeach a deputy president or how not to impeach.
Wait, do we not have that clear in the Constitution?
No. You know, there's no perfect law. And every law is subject to judicial interpretation.
All right.
Remember that the Constitution that we have for a democracy like ours has been described that it's overambitious to what we have currently. And that is why every week you see different interpretations from the courts. Parliament makes a decision, the courts say, you know what, hold my beer, or rather hold my coffee, stop. The president makes a decision, and you're told, hey, wait. Now, again, it's a very momentous occasion in that the deputy president of the Republic of Kenya has been impeached. And at the end of the day, as I've said, we are going to be told how to impeach or how not to. The same way at BBI, we were told how not to do a constitutional amendment through popular initiative.
But you know, you ask lawyers about this, by the way, just before my brother Munyo comes in.
Okay.
You know, we might be blamed for sometimes misleading the country in the way in which we interpret the constitution and the laws conveniently. Actually, the law is clear. The law is right there. I mean, if you are sick, you've got to be given a chance to heal, and then you proceed with whatever you are doing if you are before a tribunal, a court of law. So, but you twist it. And the most interesting thing is the most brilliant of minds are actually the ones that pull the other side, not because they are protecting the sanctity of a doctrine in the Constitution, but they have some form of master behind their thinking, so they interpret the law in a certain way. And this is really unfair. And I always call it, it's intellectual manipulation.
Intellectual manipulation. And it is true to that fact. I have personally engaged quite a number of lawyers and advocates, each of them interpreting even the orders in different ways. For Kenyans, it could be a bit confusing, but I agree with what Wakili has said. But let me talk to the governance consultant to this point in time. Your overview of what has been happening and what impact it has on governance, because deputy presidency is very paramount in governance, as far as the Republic is concerned.
I think it's precedent setting, obviously. And like my colleagues have said, there's no perfect way of looking at this or doing stuff. It keeps on improving. It's going to be a new, we're going to have a lot of information. Remember, even way back when we go to the National Assembly, when we were conducting public participation, you saw what happened. The whole country was excited. All of a sudden, you're being told, go back. It is not at the county level. It is at constituency level. You guys were elected at the constituency level. We go to many people, you don't understand what is happening. When you go to the Senate, what exactly is going on? Went to the Senate, we saw what happened. And now, we are in court. So, naturally, if you're on this side, you are expected to pull on that side and push an interpretation that favors your position on this matter. It is that simple. And that is why you are there in the first instance. If you do anything else, then it will be absurd. So the correct version is the one that ultimately is accepted and appreciated by the bench that is there to determine who has pushed the court to appreciating the position that they have. I think it is that simple.
And I'm glad that you brought in by the bench, because we're going to be speaking about the three-judge bench challenged in the courts today. They took a break. We'll hear about it tomorrow. But before I do that, for those who missed, probably they were chasing the bag or hustling. This is just a glimpse of what happened today, this morning or afternoon rather, in the courts, in as far as the hearing or trial of the Deputy President impeachment is concerned. Just take a look.
Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the hearing process. And from this court, we shall all march forward with confidence. If I may quote Mutaje Makinata, before and buried my attack on you. Let us talk about time. Where are we going?
My Lord,
where are we going with
Prince Dr. Camino?
With respect, will you speak to that? Camino is talking. Will you sit down? I am talking.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I as senior counsel.
I will not speak down. We're not practicing lawyers. We're doing breastfeeding.
That is also so my Lord.
Just a glimpse of it. That went, and of course we had that particular trial pretty much the whole day. But that has really taken, center stage. But why were we even in the court in the first place? I want to hear from the from the lawyers in the studio and the governance experts. Impeached Deputy President Rigathi Gachagua was in court today for the hearing of 2 consolidated cases linked to his impeachment removal. One challenging his removal from office, and another seeking to clear the way for the swearing in of Interior CS Kithure Kindiki as the next DP. Now you're in the know. But gentlemen, the temperatures in the courts today, that's where I'm headed to, when we were not even agreed on the 3-judge bench to start with. What are we expecting?
I think you give me the benefit of always starting before Senior Ishmael here has to probably tell us more, because by the time he started practicing, I was still breastfeeding. So I give him the benefit of doubt as our senior. But then the main reason why we were in court, as now popularly we are calling it, it's the Kerugoya matter and the Nairobi matter. And the Nairobi orders were specific that then the Senate resolution, the implementation of the Senate resolution is halted until that case is hardened and determined. But then the Kerugoya matter, my reading of those orders were very specific to the person of Kithure Kindiki. And they said, you know what, Kithure Kindiki, you should not assume office until this case is hardened and determined. And in quest for that, we know that all those files were consolidated, were brought to Nairobi. And once they were brought to Nairobi, they were brought to the bench. And one of the first issues that then became up is who, first of all, put the bench together. And that is the discussion, basically, we have had the entire afternoon. And the moment then, you know, there's a term we say that jurisdiction is everything, in that before any court can proceed to hear the merits of any case, before any court or any tribunal can proceed to hear the substance bit of it, then it has to be convinced that, you know what, I have that authority from the law to be able to listen to this matter and make a determination. That is why today we are basically doing housekeeping. All right. So that at the end of the day, if then, depending on how the judges will come back and they say, you know what, we were not rightly convened, then they lift up their hands and they say what? The files go back to the Chief Justice, then we proceed on to have a different bench hear it. So we are yet to get into the substantive bit of it. Again, depending on the decision that comes out tomorrow, it's when we now move to the next level of the substantive bit. I'm
coming to you, Charles, but this begs the question, what is really the error or problem that is surrounding this particular empanelment by the Deputy Chief Justice, Philomena Mwilu? Perhaps maybe we could just bring us closer, Naribo, to why it is an issue that it was not a direct appointment by the Chief Justice, but by her deputy.
Well, first and foremost, it is law. I mean, if a party goes to court and feels that the matter is so substantively huge, of public interest, a lot of complex issues relating to the Constitution and the laws, of course you request for empanelment, and the person you request is not the Deputy Chief Justice, but the Chief Justice. So that is just the law. It is the way it is.
So she cannot delegate?
Has she delegated? Now that's why we are here.
All right.
Did she delegate? That's now what exactly is going on in the High Court. It was what was going on in the High Court today. So we want to see that, yes, she did write a letter to the Deputy Chief Justice, or she should confirm it is true, I did. But it seems that the experienced practitioners, and you need to understand this once, in case you go to court one day and you pick a lawyer. Lawyers don't lose cases because they are very stupid. I mean, because they don't understand what concept of law is applicable. Lawyers lose cases in the process and the manner in which the file is handled. And every lawyer who is a litigator in court will tell you, if his case is coming for hearing tomorrow at 2 p.m., but you all of a sudden find it coming to 11 a.m. in the list, then you know you are already cooked. And if you say, oh, I'm going to be given 1 hour to address the court, and then you reach in the court and the judge says, I want to give you 5 minutes, then you know you are cooked. So experienced litigants, lawyers especially, understand that the movement of the file, if judgment is coming tomorrow, but when the day of judgment is coming, then the judge gets a dental problem, which is possible, and I am not saying it cannot happen. and then it is pushed to another day. Then when you are already in court by 8 o'clock, then the file does not surface, in the courtroom at 9. Then you say, what the hell? Then you go back to the office. Then the file is called at 12. So these are not small matters, by the way, as it may be concluded by lay people. A litigant must guard and follow his file. That is why now we came into virtual digitization processes in the High Court, because we were suffering not only backlog, but we were suffering also an important file just gets lost.
All right.
You keep wondering, but it was here, it was the Pigeonhole. Who took it? So to stop all these shenanigans, the country decided to digitize the judiciary, a filing system. And therefore, if you file a document today in the judiciary CTS, the portal, it goes in a certain way. So when you realize it has not gone the normal way, but a judge has come to the High Court at 10, 12 in the night and made orders, definitely, if you intend to protect the interests of your client, you must ask, how did this happen? So it is not like many other lawyers are saying, no, you need to make a formal application. Where is that formal application that was made for the Deputy Chief Justice to come inside the court and give certain directions? There is no such an application.
Right.
So, but you are asking me, you need to make a formal application. So every experienced advocate knows that he loses at the manner, first of all, in the way in which his file is handled, not just going to, cite the provisions of the Constitution or the law. At least that's what I know.
And I like that you're explaining this to the common man to understand the seriousness of what might look entertaining. Before I take a very short breather, Charles, your understanding of, because we are working within the Constitution, we have a timeline here, and we cannot prolong the vacancy of a functional office of the Deputy President.
I think it is important to remember that if this matter is not sorted out at this level, it goes to the higher level. And issues of law are issues that are very important when it comes to dispensing with matters of this nature. So everything that is happening is important, so that by the time a decision is made on the substantive issues, it is made after everyone is clear and appreciative of these decisions that have been arrived at, how they were arrived at, and now how they should be done. I think, again, is precedent setting in the sense that if you read Article 165 on paneling of the kind of panel that we have, because the matter was certified as having raised substantive issues of law, that is given to the Chief Justice. So the argument on the other side is, much as it was done by the Deputy Chief Justice, the Deputy Chief Justice can actually do that. Yeah, so that is the issue for determination, whether this was done procedurally or not. And I think there are precedents in that regard, but I guess we can only wait until tomorrow to have that dispensed with.
All right, we can only wait until tomorrow. Stay with us as we continue to dissect what is happening in the courts with the help of the legal teams here. And